Welcome, everybody. Happy to be here. As Sarah said, my name is Ryan Stevens. I'm one of the owners of Griffen and Stevens. We're over on North Humphrey Street here in Flagstaff, depending on where you're zooming in from. And what I was asked to talk about was setting aside a criminal judgment. So we're going to jump right in. Setting aside a criminal judgment is Arizona's version and Arizona's articulation of how we can improve somebody's record after they have a criminal conviction, not a criminal charge necessarily, but a conviction, and have satisfied all terms of judgment. So they've received a complete discharge from the court. The main statute that we'll talk about is this one. You don't need to remember the number, but I like to be specific. So that's the set-aside statute, Arizona Revised Statutes 13-905. And one of the new aspects to it is this thing called a certificate of second chance. And I'll be adding that into the slides and the presentation today so that you get an idea of what that is. I'm going to go through a couple of statutes that are going to be relevant to our discussion. 13-904 has to do with the suspension of civil rights that only applies to felony convictions. So not misdemeanor DUI, misdemeanor shoplift, misdemeanor disorderly conduct, but actual felony convictions. Your privilege to serve on a jury, to vote, to run for office, to possess a firearm are suspended if you have a criminal felony conviction. And then there are certain things you can do to undo or fix the suspension of those rights and restore those rights. But that's the statute that talks about the suspension. The other relevant statutes here are going to be just after the set-aside statutes, so 13-906 to 908, and that talks about restoring a variety of those civil rights that I just discussed. 13-907 is for first-time felony offenders, and that is if you complete your sentence entirely, whether it's prison, hopefully not, probation, you receive a complete discharge, you've paid any restitution that is owed, and you've paid off your court fines and fees, your first-time offender civil rights will be automatically restored, except for one, and that is this one. The restoration of the right to possess a gun is not automatically restored, not even for first-time offenders. So you do need to file something to get that right back before you can purchase or possess a firearm. And I'll explain the difference between this statute that is specific to requesting the firearm possession to be right to be restored, and how it overlaps with the set-aside statute, which is the primary focus of our discussion. There's also a little bonus section I added this morning, which is a new statute that is not in effect today, because today is October of 2022, but effective January of 2023, there is a new statute that is very much on point with our discussion today, and I will come back to this soon. So keep that in mind. All right, jumping into setting aside a conviction. Arizona, I get this question all the time, which is somebody may call either a former client who we had a plea agreement and reduced charges, or somebody who I wasn't represented and had a conviction, and they say, can I expunge my conviction? And the answer is no. We don't have expungement except for a very limited circumstance, which I'll talk about in a little while. But we have this separate process called setting aside a conviction. The next question everybody asks me is, what does it mean to set aside a conviction? Unfortunately, it means what it says. The Arizona legislature, in conjunction with the governor, came up with this phrase, setting aside a criminal conviction. The governor, Doug Ducey, then came up with another idea, which was recent, and that was to add this certificate of second chance. What does it really mean? They really just don't want to say the word expungement, in my opinion. It seems to me they just don't want to give people the benefit of wiping a record clean. But they are allowing different things that can be done in order to improve people's lives, and specifically their ability to get professional or occupational licenses, to get housing and not be discriminated against in housing, and have better employment opportunities despite maybe having a prior conviction. So those are the things we're talking about. In 2014, the Arizona Court of Appeals said that the set-aside statute is not intended to eliminate all consequences of a person's criminal conviction. So it's important to understand that a set-aside is helpful. It's a step in a positive direction, but it is not a leap to completely cleaning someone's record. And it does not change the fact that a conviction at one point did exist. It doesn't change history, but it changes, hopefully, creates a better future for the person. So that's what the Court of Appeals has said, and that's a quote. We'll come back to that as well. I kind of joke about this. I mean, no statute is simple and easy. It is relatively straightforward, but so I don't mean to suggest it's overly complex, but they couldn't just make it simple where you file a petition. There are factors a judge must consider. You have to file it correctly. You have to be one of the people authorized to file it. You have to potentially have a hearing. The victim, if there's a victim in the case, so maybe not a possession of drug case, but maybe let's say domestic violence case, there's going to be a victim. They have a right to be heard. So there's a lot of factors that we have to address in the statute. With exception, every person convicted is eligible. Of course, there's exceptions, but generally speaking, the only ones, we'll get to these, the only ones that are not eligible are the most serious felony convictions under Arizona law. And it used to be that some of the least serious non-felony, meaning misdemeanor convictions, were not eligible, but they have changed that law recently. So pretty much anyone who has a criminal conviction is eligible for this, with exceptions that I'll go over. Those exceptions, we have to jump all the way down to subsection N, which we'll do now because it's an appropriate time. A dangerous offense is something involving typically very serious physical injury to another person, the use or display of a dangerous instrument, or the use or display of a firearm or deadly weapon. So cases involving guns, road rage, pointing of guns, somebody swinging a knife at someone, not eligible for setting aside. The other big category for not eligible are sex offender registration or sexually motivated offenses. So that's what SOR and SM mean. So anybody who's required to register as a sex offender, their conviction is not going to be eligible to set aside. The other one, which doesn't come up as often, but if a victim, so if there's a child neglect case or a child abuse case or any other, I mean, frankly, any other crime, you can commit, criminal damage technically against a child. Anybody under the age of 15 who is a victim, that offense, if convicted, cannot be set aside. So those are exceptions. The good news is, those are the most serious crimes, and they don't represent the large majority of criminal defendants, which means most people are eligible. So that's good news. If you have any jail time, like a DUI, you might have to do a night in jail, things of that nature. And then probation terms, especially on a felony, you might get 3 years of probation. You got to get it all done, and then you can apply. Basically, to put it another way, you have to be discharged by the court. So the court has stopped having jurisdiction over your sentence because you did everything asked or not asked, but directed by a judge, and therefore you can apply. And when I say apply, that's what the statute says. So it's not automatic. It's not a guarantee. Your odds typically are very good because I think judges feel very strongly about granting set-asides when people have succeeded on their sentence. Of course, if somebody had a number of probation violations, they may face more resistance to a set-aside later. But when you say they may apply, you do have to fill out an application or a petition, and you have to figure out from that point forward, what the judge is going to do about it. One of the newer parts that we like about the law, that I like about the law, is at conviction. So whether somebody's sentenced on a felony or misdemeanor does not matter. The judge is required, it says the word shall, to inform the defendant of the right to set aside. So it used to be that people would walk out of court with a conviction and not even be told that they can do this. Now the judge has to tell them, which I really like because it educates people who maybe wouldn't have known. Couple of things about the application, pretty straightforward. The defendant, meaning the convicted person, can file. The person's attorney can file, so lawyers, of course, can file. This one I've never seen happen, but technically their probation officer under the statute can file to set aside. So I hope they're doing that when somebody does really well on probation. And the law does not allow the clerk of the court to require a filing fee. So it is free to file, which means there's no financial harm to file. in my view, there's no reason not to clean up records once you've earned the right. These are really important. This is, if anything was the most important part of the presentation today, it's what I'm about to say. The court is directed to consider certain factors in deciding whether to grant or deny a petition to set aside. They are what you might expect, but let's go through them. The nature and circumstances of the offense. So if there's a particularly violent crime, or somebody was caught selling, pounds and pounds of methamphetamine, judges may look at that and say, the nature and circumstances of your offense are really quite bad. So you better have a lot of good elsewhere for me to grant this. But the majority of cases that go through the system are going to be okay to pass this test of nature and circumstances. Compliance with probation and sentence. I mean, if you have 15 probation violations and you squeak through and barely make it through probation, I think that's going to be tough for a judge to grant your petition later. But for those folks who are very successful on probation, or maybe they had to do a jail sentence for a DUI and they did what they were supposed to do when they were supposed to do it, you're going to get a check mark for that factor. They'll also look at your prior and subsequent convictions. I thought that this factor was going to hurt us on a lot of cases, but I can tell you I've had some really long petitions where I've had multiple prior convictions, and for some of them subsequent convictions in numerous courts throughout the state. And I just did one for a gentleman who really cleaned up his life, but we had to go to 4 separate courts, and in most of those courts there were at least 2 cases, so we had to do about 7, I think it was 7 or 8 set-asides. And we have to be honest in the petition, so we included in there that he has prior convictions and he has subsequent convictions. Every single petition was granted. So even if you have priors, or even if you got yourself in trouble again, do not give up on your petition to set aside. In fact, file one in every case that you have. Victims' input matters, of course. If there was a victim, it's pretty rare that we see a victim provide input, because it means the defendant has completed their term of sentence, has done what they're supposed to do, has paid their restitution. So sometimes a victim might still feel upset about what happened and object to the set aside. Haven't seen it, and I think even if it happens, feel pretty good that a judge would still consider granting it. Restitution matters. That's restitution, just in case anybody doesn't know, in criminal law, restitution means economic loss, meaning financial harm caused by a crime. So if I stole an Xbox from Walmart and it was damaged, or it couldn't be returned to be sold in its original condition, I'm going to owe several $100s in restitution to Walmart, because that was a financial harm I caused with my shoplifting. That's important. I can tell you right now, most judges will never grant a set aside if you haven't paid the restitution, because restitution is a victim's right, and it's very important that it gets done. So my advice on restitution is so important. Judges find it so important. Absolutely, work overtime, but get it done so you can pay that off. Length of time since completion of sentence. This is something I have a bit of a disagreement with on the prosecutor's office oftentimes, which is after you've successfully completed, probation or jail time or alcohol counseling, generally speaking, I think that people who have proven themselves should file their petition to set aside. Judges sometimes say, I want to see a person do a few months after the completion of their sentence before I see the petition. And prosecutors sometimes file an objection to a petition to set aside. I had a few locally where on a DUI case I filed, and first the prosecutor objected, and she said, I just don't think a DUI should ever be set aside. Wrong. The law says it can be. It's not up to her personal opinion. The judge granted it. In another case, instead of taking that position, she said, well, this person hasn't waited long enough. Yes, they completed their sentence. Yes, they did their counseling. Yes, they did their jail time. They did everything we ever asked of them, but they should have to wait longer. Also denied. The judge granted the petition, denied the prosecutor's objection. So length of time seems to be, it's in the statute, but it seems not to be overly influential. But you could always reapply. So if you get denied on day 1, wait 6 months, file again. Age at time of conviction certainly matters, especially for younger folks, college students, high school kids that are over the age of 18, because we're talking about, by the way, not juvenile delinquency right now. We're talking about adult court convictions. So the younger the age, I think the more likely to grant. And then the last factor in subsection C says any other relevant factor. So that is an open invitation, in my opinion. And so far, so good. What I typically tell people is if you're concerned that maybe your petition could be denied, I tell those people, go to your boss, see if your employer will write a nice letter for you talking about how hard you work and how reliable you are. See if a family member or a loved one or a friend would write a letter saying, wow, I've really seen the changes in this person. They took probation seriously and really proud of how they're doing. And frankly, anything else, if you volunteer on weekends, tell the judge, whatever it is, paint a positive portrait of yourself in these petitions, because any other relevant factor is what we want it to mean. Anything that we think is relevant, we can submit to the judge. So I've done ones where we had a packet of information where we said, look, the crime was rather serious. We've come a long way since then. Here's all the exhibits with all the wonderful information about my client. And that typically a judge will review and oftentimes grant. So then when we move on, so those are all the factors that can be looked at by a judge. Once we move on, if you receive a granted set aside, then a couple of things happen. You get an order that says, like I said, the statute is what it is. It says the order shall say that the judgment of guilt is hereby set aside. And this language is amazing. It says the language of the order shall dismiss the complaint, information, or indictment. That is really, really good. And I always give a proposed order with this language because it shows, if you ever get it signed, you can show that order to a potential employer or to anybody of importance, and it looks like the whole thing was dismissed. It's not technically dismissed in terms of historically the conviction did occur. But for whatever reason, the statute says that the order shall dismiss the complaint, information, or indictment. For those of you that don't know the difference, a complaint is typically done in the municipal or justice courts. So a ticket and complaint would be, any misdemeanor complaint. A felony complaint can also be filed in a justice court. For the superior court, which would be felony cases only, an information would be filed if the case proceeded through a justice court or preliminary hearing, or an indictment would be filed if the grand jury convened and found probable cause. Basically, to summarize those three things, the charging document that listed the charges against you would be dismissed by this, which is just wonderful language for moving forward. The other thing the order has to do is release the person from all penalties. And then there are some exceptions. So in subsection D, it does not affect ADOT. It does not affect MVD, which means if you have a DUI and you got a refusal suspension, you refuse to provide a breath sample, they got you on a refusal suspension for 12 months. You could go get a DUI conviction, you can have it set aside, and your suspension or driver's license revocation will unfortunately keep going. So this does not mean it fixes your driving privileges. If you are required to do traffic survival school, also not vacated by a petition to set aside. So you've got to do, that's just another driving MVD requirement. Anybody who reaches 8 points on their license, reckless driving is 8 points, DUI is 8 points. So either one of those, you're going to get a traffic survival school, and it's not going to, the set aside is not going to fix that. And then there's game and fish penalties, which they're financial penalties typically for taking wildlife unlawfully. Other things that it doesn't affect, meaning they just phrased it differently in subsection E, a conviction that is set aside can still be used for some things. For example, a person who has a DUI conviction, their very first DUI conviction, if that conviction is set aside, but within 7 years of their first conviction, they get another DUI. You cannot go to court and say, well, my last one was set aside, so you can't use it. The law says that's not true. they can use it even though it was set aside because it's admissible had it not been set aside. Alleged as an element of an offense, very similar. So DUI is a very, a second offense DUI is a very common situation. Second offense shoplifting. So shoplifting offenses add up on you. And second and third offense, domestic violence. So those are the big three: DUI, DV, and shoplifting. Those are the ones where if you have a prior within a certain number of years, your offense penalties go way, way up very quickly. And setting aside your prior is not going to cure the problem. The other big one is for felonies only. Arizona has repetitive offender sentencing. So if a person had two prior felony convictions in let's say in 5 years, and they got an aggravated DUI as a third offense within 5 years, setting aside the convictions will not help you. You would be a category 3 repetitive offender. You would be facing 8 to 12 years mandatory prison time. So I think what the legislature is clearly saying is you're not going to get out of 8 to 12 years of mandatory prison by setting aside a conviction. I think it maybe comes without saying, but that's what the statute says. We need to be very clear. And anything else that can be proved in a subsequent prosecution. So basically, I'll just tell you, those kinds of convictions, as well as ADOT suspensions, and that there's a theme here. And that theme is it'll clean up your prior record. Setting aside a conviction will clean up your prior record, but it's not going to help you if you go commit a future crime. You're not going to be able to look back and say the set aside should mean that you're treated differently. So what does it mean in any sort of practical sense? We get a little bit of insight from subsection F. That subsection tells us this, which is the clerk of the court where the conviction occurred must notify the Arizona Department of Public Safety. You see those troopers on the highway, right? You see DPS troopers pulling people over for speeding or drug trafficking. So why does the clerk of court have to tell them? Well, because DPS has troopers on the interstate, but they also are the state repository for criminal histories. So when the Department of Justice, the feds, want to know if somebody has a state criminal conviction, they will dip into the DPS records because that's where your conviction is permanently housed. So that way a person doesn't have to, if they want to look up someone's criminal conviction, they don't have to go to every single court in Arizona, which would be virtually impossible. The DPS records, especially the government access to those, will be containing, let's say, all of your criminal convictions within the state. So that's why the clerk sends it to them, because they have to update it and they are required to add an annotation, which is nice in some fashion. It makes your record look better and it shows that your set aside was granted on your permanent official record. One comment about the DPS record: if you have, especially if you may have had a criminal conviction years and years and years ago, and you're scratching your head thinking, I don't honestly remember, did they designate that a felony? Did they designate that a misdemeanor? Did they dismiss it after I did counseling? What is the status of that? You can go to the court where it happened and try to get a copy. If it's more than a certain number of years old, the court probably destroyed the file. So then what you can do is you can go online and you can look up Arizona DPS criminal records, and nobody else can pull your record. It is sealed, but you can pull your own record. So they make it kind of hard. You go through the website and you'll find a section that says record review packet. You click on that and there will be an application, and you will actually have to provide a fingerprint because they're going to run it to make sure it's you, because these are sealed and they are not public to other people, but you are allowed to see your own. And then you can just have them email your own record to you. And I think it's wise, if you think you have a conviction and you're not sure, I think it's wise to have that saved if you ever need to apply for a job or apply for some sort of government benefit. Nice to have that, so you can show exactly what the DPS record shows. DPS, according to the set-aside statute, may not redact or remove any part of the person's record. So that's really important, because when it is, remember it says annotation of set-aside, they're going to annotate, meaning they're going to add something in there saying conviction set aside by judge, complaint information or indictment dismissed. but they're not going to erase what was already on your record. So the record gets longer, not shorter, but that's so, frankly, the government, the DOJ, Federal Department of Justice, a lawyer, a judge would be able to review it and not wonder if anything's missing if they can read the whole record. So once again, there's another theme there, which is setting aside a conviction is something less than expungement. Expungement would mean erasing a record, like it didn't happen, basically, and that's not what setting aside is. Subsection G gives us a little more insight. It explains that fingerprint clearance. So for those of you who work with medical patients, kids, so if you work in a school setting, if you work in a nursing home or hospital, fingerprint clearance is generally required for a lot of professions. DPS, shockingly, also handles fingerprint clearance because they have access to your records. Makes sense. Setting aside a conviction does not mean that your fingerprint clearance will automatically be restored. So if I had a very serious conviction, say I had an aggravated assault on a law enforcement officer conviction, I actually can set that aside, even though it's a serious crime. But you can pretty much guarantee that DPS is not going to give me fingerprint clearance probably ever again. A couple other things about the statute before we move on to the couple of additional topics. Subsection I, can a judge deny a petition? The answer is yes, but not so simple for the judge either, which I like very much, is this quote. It says, the court, meaning the judge, shall state its reasons for the denial in writing and on the record. So number one, a judge cannot simply write denied and hand it back to you. Can't do it. Has to come up with valid reasons. That is good. It keeps judges from denying them against maybe somebody who was on the fence, they're on the fence about. They have to give it further thought. Additionally, it's got to be done in writing. So they cannot just simply say on the record, petition to set aside, denied, have a nice day. Can't do that. And then in addition to writing up an order with the reasons, even better, they have to also do it on the record. What does that mean? Well, on the record means you get a hearing. I like this because it means set-asides are to be taken seriously. The legislature is saying, judges of Arizona, if you're going to consider denying a set-aside, then you're going to need to put the time in. You're going to need to have a hearing. You're going to need to give the parties or participants a chance to be heard. And if you're going to deny it, you're going to have to do more work, frankly. And I understand in some cases judges may do that if it's appropriate. But in general, I think that this encourages in many ways judges to consider granting. You can grant a petition without a hearing. There are some additional rights. The most significant person or party who can attend a set-aside hearing would be a victim. So if there's a domestic violence or something, if the person is still very upset about the crime, they have a right to come to the hearing. The prosecutor's office has to notify the victim of the hearing so that they have the right to be heard. I've never had a hearing where a victim showed up and opposed. And I would say probably over 95% of the petitions I file, we don't even have a hearing. They just get granted. I just did one I'm obviously a lawyer in Flagstaff. I just did one in Phoenix Municipal Court. And I like what they did. The judge set a hearing and said, you're welcome to come and argue your motion, but I'm not requiring you to attend. I will consider what you sent in your petition. I'll consider the exhibits. So if you don't have anything further to say, great. If you do, you can come to court at this date and time. We decided our petition was strong. We decided not to attend. We didn't want to draw further attention to it. And we just found out the judge granted it in our absence. So I like that procedure. I thought it was very good. This is really important. I mean, this means a lot to a lot of people in Arizona and beyond. If you get a conviction, a felony conviction, remember, we're talking felonies for firearms. If you get a felony conviction set aside, really, really good news. The person's right to possess a firearm is restored. So this is very, very important, actually. So if I have a felony conviction, let's say felony shoplifting, I just made that up, but felony shoplifting conviction, I'm going to lose my right to possess a firearm, even though my crime had nothing to do with a gun. That's just you're a felon, no firearm. Well, I want to be able to buy a gun. I want to go hunting. So here's the issue. If I file a petition to renew or restore, restore my firearm rights under 13.910, there are all these steps to go through, and it might be denied. And in fact, I might be told I can't do it for 3 years or 5 years. But if I come to the set aside option and I file a petition to set aside my conviction, boom, I won. I got my firearm right restored without ever having the separate petition. It's made a big difference for these folks who really appreciate the right to possess a gun. So in all my petitions now, I give an order, and in the order, I include a separate section that says it is further ordered that the defendant's right to possess a firearm is restored as to this case pursuant to ARS section 13905M. And judges have routinely been signing that, and it's really helping people out. There is an exception, of course. If your felony conviction is called a serious offense, then you are not going to get your firearm rights restored with a set aside. So serious offenses would be what you might imagine. Murder, rape, DCAC just means dangerous crimes against children. So really, young victims on violent or sexual crimes, arson, armed robbery. Those are ones where maybe you would expect you're not going to get your firearm back anyway. Other than those, your right to possess a firearm is restored. Jumping to 13.910 very briefly, because we're going to move on to the new topic and the sort of breaking news type stuff. You cannot file for the restoration of a firearm possession for 2 years from absolute discharge. That's under 13.910. So not under the set aside, you can file sooner. But if you specifically are requesting firearm only, or if a judge won't grant your firearm rights restored, you got to wait for 2 years until you're done with probation or prison. So 2 years is a extra waiting period, not required for a set aside, is required for firearms. All right. As of August 27, 2021, the governor and the legislature have passed the new law that says you have the right to apply for a certificate of second chance. So that's very exciting. And it is found in the set aside statute. So it is in the same 13905 statute. For misdemeanors, it's automatic. So if you get and it has to be your first one, I should say. For first misdemeanors, if I got a DUI and I've never had a prior crime, if I get a set aside granted, then the certificate of second chance automatically grants as well. If it's a felony, I can have my set aside granted within, immediately after my discharge of sentence, but I have to wait depending on the class of felony. So we have 6 classes of felony in Arizona. The lower is the more serious. So class 1 is murder. Class 6 might be possession of, paraphernalia. 2 years for low end, up to 5 years for more serious crimes. So what the heck is it? A certificate of second chance protects you if you have an occupational license. So if you're a nurse and you need to go to the Board of Nursing, if you're a teacher and you need to go to the Education Board and get a license for a professional occupation, a certificate of second chance means they cannot refuse you because of your criminal conviction. It also protects employers who maybe didn't want to hire an ex-felon or ex-con because they're worried that if that person assaults a customer or is negligent at work, the employer could get sued under the tort theory of negligent hiring. So finally, the legislature said, if you get a certificate of second chance, you can show your employer that, and your employer is protected from being sued for hiring you. So that's really nice because it's the obvious concept is let's get people working and stop denying them jobs. Very similar situation, which is landlords. If they're going to provide housing to an ex-offender, as they say, or ex-con, they cannot be sued. They are protected from the concept of negligence. If there's an apartment in Phoenix and somebody gets assaulted or somebody's house gets burglarized, the landlord gets sued for letting an ex-con live there because there was higher risk they would commit a crime or something. That old thinking is gone. No more can you do that if they have the certificate of second chance. So certificate of second chance is good. It doesn't cure the world's problems for the person who had the conviction, but it's a step in the right direction. Real quick on these, 904 talks about what is suspended for felonies. So we talked about running for office, sitting as a juror, firearm, and voting. 906 provides a process to get those rights restored. It's very similar to filing for a set-aside. It's a little beyond the topic for today. I just want you to know about it because it's relevant. 907 is for first-time offenders. You automatically can get your rights restored. The one thing that I would say, if you're planning on voting, if you have a prior felony, even one, and you're planning on voting, would really encourage you to file a set-aside and also file under 906 and be very clear that your rights are restored. Because I hate for people to show up on voting day and for the voting logs to show that perhaps that person has a felony and it wasn't automatically restored. You might know Prop 207, if that rings a bell for anybody. Who knows if you voted for it, yes or no, but the voters of Arizona agreed to have expungement, which I'm talking about, as well as possession and production of marijuana. So Prop 207, for today's purposes, is relevant in that you can do something more than set aside. This is the only area of Arizona law where you can expunge a prior conviction. So if you had 2.5 ounces or less of marijuana, or 12.5 grams of marijuana concentrate, THC oil, little vape cartridges, things of that nature, file an expungement petition, get it off your record. Make DPS erase it from your record. It's a moral victory, but it also is a really good victory for your criminal charges. Anybody who was convicted of having 6 or less plants of marijuana or paraphernalia also can expunge. So remember this slide. So we're at the final sort of topic that's brand new. In 2014, we learned from the Court of Appeals that setting aside is not intended to eliminate all consequences of a person's criminal conviction. But here's a new law. Now it's not setting aside, and it's also not expungement. Sorry. But they came up with yet another way. So we had set asides, and then we had certificate of second chance. And now they're doing one more thing because they just really don't want to give us the right to expunge. And here it is. We are now going to be able to start petitioning to seal records. That will not occur until the law goes into effect January of 2023. So we're getting up to it soon. It's a very long statute. I have it printed out. I'm not going to go through the whole thing, but it's basically similar in some fashions to a set aside. You have to file a petition. You can have an arrest sealed. So if your case was dismissed, you don't even have to have a conviction. So if you had a great result and you say, I just hate the fact that I have this, criminal police report out there on me, even though my case was dismissed, move to seal it. Absolutely seal it. We're gonna be filing a lot of these. I think it's going to help a lot of people. There's a waiting period. If it's a small misdemeanor, so a criminal speeding, you have to be 2 years past it. If it's a class 1 misdemeanor, is 3 years. So DUI, reckless driving cases, shoplifting, the domestic violence stuff, those would be class 1 misdemeanors, and you have to wait 3 years. For less serious felonies, 4, 5, and 6 class, it's 5 years. And for a really serious felony, you got to wait 10 years to seal it. So it's not perfect, but I'll tell you, it's going to be nice that people can just do everything, right? So you get a felony offense, you lose your rights, you complete your sentence, file your petition to set aside, get your firearm rights restored, make sure your civil rights are restored, file for your certificate of second chance. And once you've waited the right amount of time, file to seal. By the time you do all that, I feel like the Arizona legislature is going to regret not just letting you expunge, because you've basically accomplished expungement without using the word. So that's it for now. That's where we're at on all those things. Sorry, I talk a little fast, but pleasure to speak about these important topics. Really happy to hear when people clean up their records, because I fight for people who have criminal charges pending. There are a lot of good people out there who have a bad day and get themselves in trouble. And this is just a wonderful way for them to move on with their lives when they've proven that they've moved past it. So thank you for joining us.